Okay. All right, everyone. Welcome to our webinar today, and thank you for joining us. My name is Margaret Henn. I am the Director of Program Management at Maryland Volunteer Lawyer Service, and this webinar is on guardianship of the person and property appointments, and we very much appreciate you all being here. We are very lucky to have with us today some in-house experts from MVLS who are part of our Adult Protective Guardianship Review Board team. And those are Janet Fetter, who's our managing attorney, and Caitlin Tepe, who's our staff attorney on that project. And I do want to really thank them for being here. You all in the audience may or may not know that guardianship proceedings are some of the only proceedings that are still going on, even though many parts of the court are shut down right now. So they have been, in fact, working overtime in this time of the court shutdown. And so I definitely want to thank them for taking the time to be here with us on this panel today. Just kind of why we're having this training. We hope that some of you will consider taking a pro bono guardianship training case with MVLS. This is one of the services that we offer to our clients, and you really can make a difference in the life of your client, who will be the petitioner for guardianship, as well as the person with the disability that they are getting guardianship over and needs their help. So we do thank you for your interest in this topic and for your interest in volunteering with us. I'm going to introduce our presenters in a moment, but I just want to mention that I am happy to send out the PowerPoint to anyone who wants it. This training will be recorded. It will be available on our website, and the materials, the PowerPoint, will also be available on our website. So after the fact, if you're interested in going back and reviewing some of the materials, you can do so. The audience will be muted during this presentation. And so if you have any questions, please type them in your chat box or your question box on your screen, and I'll be collecting those questions. And at the end of the presentation, I will give those questions to our presenters to answer. So please feel free to type questions, but again, you will be muted during the presentation. So at the end of the presentation, I will go into a little bit more about how volunteering with MVLS works and some of the other trainings that we have available. Just wanted to talk a little bit about our presenters before we dive in. So Janet and Caitlin actually work on the opposite side of the guardianship proceedings from what our volunteers will be doing, but I think that gives them very in-depth knowledge and will be very helpful to all of you in learning how to proceed with these cases. And in addition, this is all they do all day, every day, so they really do have quite a wealth of experience in this area, and I want to thank them both for participating. So Janet Fetter is a graduate of the University of Maryland Law School in 1991. She clerked with the Honorable David Ross of the Circuit Court of Baltimore City. She joined MVLS in 1994 and has been with us since then. So she has quite a long tenure with us and on guardianship cases. She has been the managing attorney on this program since 2015. And Caitlin has come to us recently. She started with MVLS in January. Prior to that, she's a graduate of University of Baltimore Law School, and she worked for Maryland Legal Aid for 6 years, primarily on public benefits and housing cases there. So we are very happy to have both of them, and I think with that, I will go ahead and turn the presentation over to Janet.
Okay, thank you. Margaret, can you go to the next slide, please?
Yep.
Okay, so that is Maryland law that governs guardianship cases. Now, before I step into this, I guess I would like to say, again, thank you for joining us today. And we appreciate you giving us your time to go through this presentation and then to accept an appointment where you would represent a low-income Marylander who would like to petition for guardianship for a loved one. Could be a family member or a friend. And as Margaret said, we represent the opposite side. And by that, we here at MBLS, the staff attorneys, we represent the alleged disabled person who is the respondent in a guardianship case, the person against whom or for whom the guardianship petition has been filed. And you will represent a petitioner. Now, if you do accept a case from us where you represent the petitioner, we will not represent the alleged disabled person because that's a conflict. So a different vendor or attorney in Maryland would be appointed to represent the alleged disabled person in that case. But certainly we here at MBLS would be happy to help you in those cases if you need assistance just on getting through some of the intricacies of filing a petition. Okay, so the governing law. We're governed by the Estates and Trusts Article, Title 13, Guardianship of the Property and Guardianship of the Person. There are special Maryland rules, Title 10, that pertain specifically to guardians of the person and guardians of the property, and as well as the basic standard rules of Maryland. And there is some, but very little case law in Maryland concerning guardianships, but it is useful to know. And Caitlin is going to talk a little bit about that at the end of the presentation. So Margaret, next, please. Guardianship forms. They are your friends in these cases. Recently, I mean, like in the past 3 years, Maryland has really kind of tightened up or made more formal the process of filing a guardianship petition. I first started doing guardianship cases in 1994. There weren't any forms really. Different lawyers would say different things in their petitions, physician certificates, which we will get into later. They would be in many different forms and a style depending on what the lawyer created for the doctor to certify to. But now the state provides these forms, and where you can find these forms is you go to that website, courts.state.md.us, click on self-help, and then click on court forms. The guardianship court forms begin with that designation, CC-GN, and then there's another dash, and then there are numbers. There are probably several dozen of these, and they have instructions. Even there's one form that gives you instructions on how to file a guardianship petition. Many other documents that you'll need to serve, like the notice to interested persons, the advice of rights, physician certificates, the various forms of certificates that you need, the petition itself, let's see, waiver of notice, and then there are other things too that you won't really deal with just in a simple representation of a petitioner, but they do relate to guardianship and they do come into play later on once the guardianship is awarded. And so it will be to your benefit to become familiar with those forms and what's required, and that'll help you represent your petitioner too, who will likely become the guardian because they'll need to know what to do after they're appointed. So anyway, so remember those forms, and you can use those forms as is. They are fill in the blank forms, or what a lot of lawyers do is you just use the forms kind of as a template and you use your own, and then you just transform it into how you normally make your pleadings look. So that's what many lawyers do. It looks a little more professional that way, but you're free to do it either way. The courts will accept either way, directly on the form or in your own wards and such. Okay, Margaret, next please. All right, jurisdiction and venue. So in guardianship cases for adults, meaning 18 years and over, the circuit courts have exclusive jurisdiction. So those cases are always filed in the circuit court. And we'll get into a little bit more later about which circuit court you choose. Guardianships for the minor can be filed in either circuit court or orphans court, but I think usually they are filed in circuit court. Okay, and so actually, as we say down at the bottom, the petition has to be filed in the jurisdiction where the ADP, that means alleged disabled person, resides or is currently hospitalized. So if you are representing the mom and dad of a 18-year-old child, maybe with autism or an intellectual disability, and they file for guardianship of person and maybe also guardianship of property, you will simply file that petition in the jurisdiction in which they live, whether it's Baltimore County, Baltimore City, Anne Arundel County, wherever that may be. Hospitalization, you may or may not come across that. We come across it a lot because a lot of our petitioners are institutions, hospitals. Baltimore City has many hospitals. So we get a lot of cases that may be filed by a hospital in Baltimore City, yet the alleged disabled person does not reside in Baltimore City. They could reside on the other side of the state, for instance. Sometimes that happens, but they happen to have ended up in a hospital, sometimes having been transferred to a Baltimore City hospital, because we have so many hospitals here and they are large and they can provide specialized services that maybe some of the more remote hospitals cannot. But you will probably just end up filing where your petitioner and alleged disabled person are both residing. Okay, next slide, please. So what is guardianship? As I said, there are terms that are used frequently, just like jargon, in these guardianship cases. The terms are alleged disabled person, that's the ADP, and that's what a respondent is called before the guardianship hearing, before a guardian is awarded. And then once that happens, that person is often referred to as the disabled person or the ward. And a guardianship is a legal arrangement between the court, the guardian, and the ward. So the court gives the guardian the legal authority as well as a legal duty to take care of the person who's unable to care for themselves, their own person or their property. So, and guardianship is a protective proceeding because that person has been deemed not to be able to do those things on their own, whereas normally Maryland law just assumes that anyone over the age of 18 is capable and able and does in fact make those decisions for themselves. But obviously we know that not everyone can. Next slide, please. So there are two types of guardianship and they have different standards of proof. The guardianship of the person has a heightened standard of proof that's required, and that is clear and convincing evidence. Guardianship of the property is just your standard preponderance of the evidence standard. Now, you might find when you go to the actual hearing, as I often do, the judge at the end of the hearing will recite verbally their findings, and the judge will say something like, I find by clear and convincing evidence that John Smith is unable to make and communicate responsible decisions for their person and property. Now, it seems like he's clumping in property into person. Maybe that's not necessarily true, but it's just the way it's often said. But just remember that there is less a lower standard of proof for guardianship of the property. And you, as the petitioner's attorney, you have the burden of proof. And requests for guardian of the person and property, they can be combined in one petition. You don't have to file separate petitions for each one. The same person can be appointed guardian of the person and guardian of the property, or sometimes they can be different persons. And the court will issue one order saying guardian of the person and property. But then once those guardianships are created, they function separately. One guardianship can be terminated without the other being terminated. They each have separate reporting requirements, which we'll go into later. So just remember that you can file everything you need in one petition, but if a guardianship of the property and guardianship of the person are appointed, they operate differently. And, okay, next. No, you can move on. I'll get into that in the next minute. Okay, so I think you can move on to the next one, like who is the guardian? There we go. Who is the guardian? Okay, next, Margaret. So we will call the petitioner once they are appointed guardian. Just in our vernacular, we will call that person the guardian. Mom is the guardian. The brother, the sister is the guardian. But in actuality, the court is the guardian. The court is the true guardian. The court has the power to create the guardianship, and they have the power to terminate. They have the power to remove a guardian and replace that person. And so the guardian is really an agent of the court. The guardian has to answer to the court. The guardian has to file annual reports with the court. And if that's not done, or if the court is displeased for some reason, something maybe that they read in the annual report, or they have questions, they may have a clerk or someone else call you, or they may call you in, especially if the guardian does not file an annual report, the court will issue a show cause order and ask the guardian to come to court and explain why they haven't filed their annual report. So just remember that the court is actually the guardian. You have now involved the court in the lives of the petitioner and the disabled person. Okay, next slide, please. All right, so when you accept a case from us, one thing you will want to check is to make sure that the petitioner, assuming they are filing the petition to have themselves appointed guardian, which will most likely be the case, and even if they are suggesting someone else, we have to make sure that the proposed guardian is eligible to serve. Maryland law specifically excludes certain people from serving as either guardian of the person or guardian of the property. And you can see that we have a reference there to Estates and Trusts Article 11-114 and Rule 10-113, where the crimes that pertain to these are more fully explained. But as you can see, and it kind of makes sense. So a person who's convicted of a felony or crime of violence, certain assaults, sexual offenses, may not be appointed guardian of the person. And then a person who's been convicted of a crime reflecting negatively on their trustworthiness, etc., like fraud, embezzlement, theft, they may not be appointed guardian of the property. However, there is a however. The judge has the right, has the authority to overlook such a conviction, depending on either the circumstances of that conviction, or if the conviction happened a long time ago and that person has been rehabilitated, etc. As an example, just last week, I had a case where I had a petitioner a petitioner who was the daughter of my client, and she filed a petition to become guardian of the person and property, and she did have a conviction for embezzlement of public funds. That was a long time ago. She's rehabilitated herself, she's educated, she's working, and the judge did ask questions of her, and the judge was satisfied with her explanations, and I really had no doubts either, based upon my contacts with the daughter, of her ability to honestly and effectively serve as his guardian. But that is something you are going to have to make sure in the beginning. So ask your client, the petitioner, and also check the Maryland Judiciary website and wherever else you may deem appropriate to see if the petitioner will face any of those hurdles. Next slide, please. Okay, so who is the disabled person? Next slide. Okay, so under guardianship law, a person other than a minor child, for the guardianship of the person, okay, that is a person who has been judged by a court to be unable to provide for their own daily needs sufficiently to protect their health or safety. And for the guardianship of the property, they've been judged by the court to be unable to manage their own property. Next, please. Okay, and the court considers capacity versus incapacity. We usually use the word capacity, has the capacity to make and communicate responsible decisions. Sometimes you'll hear incompetence also used, but that I find that in guardianship cases, we really talk about capacity, and incompetence, you'll see it in the statute where it might say something to the effect that the finding of guardianship does not reflect on a person's competency, meaning they can still be found, and one of the things that means is that they can still be found culpable or criminally responsible for a crime. But these terms are often used interchangeably. And remember that not everyone who lost capacity in some way needs a guardian. Different people have different abilities. They might not be 100%. They may have some hurdles that they face in life to make and communicate their own decisions, but they can function and do for their own. So not everybody who has limitations and capacity issues needs a guardian. Next slide, please. Okay, and some conditions that impair capacity. We have medical disorders that impair cognition, such as dementia, which is often now called cognitive disorder by doctors. They may be caused by a stroke or vascular dementia. We have traumatic brain injuries, intellectual disability, which used to be called mental retardation, and alcohol and drug abuse. Next category that may impair capacity are psychiatric conditions that impair the thinking or judgment of a person. Depression, schizophrenia, bipolar disorder. And we here at MVLS's guardianship unit, where we represent the alleged disabled person or the disabled person, we have clients who fall under all of those categories. And they may be age 18 to 100. We do have, I know several clients who are about 100 years old or older. So it's like just about anything you can imagine that could negatively impact a person to make or communicate their decisions. We pretty much have them. And with a young person, it is often due to a disability that they have had since they were born, such as autism, intellectual disability, and other conditions such as those. Next slide, please. Okay, so the guardian of the person. Again, the guardian of the person has the legal right as well as a legal duty to make and communicate decisions concerning the disabled person's residence, food, clothing, medical care, etc. So those are conditions or issues that concern the body, health, and well-being of the ward. You will also see that the guardian of the person is also supposed to take into consideration and be cognizant of the person's social needs and emotional needs, their desire to have contact with other people, the desire to go out and do things. So those are also involved, although they're not listed on this slide. Now, it doesn't mean that the disabled person has to live with the guardian and the guardian is not responsible for physically caring for that person. Maybe that might be the case if it's a parent and child, but often the disabled person is living in a group home, an assisted living facility, or a nursing home, and that day in, day out care is given by other people. All right, next slide, please. So when may the court appoint a guardian of the person? When, by clear and convincing evidence, the court finds that the person, and we really have several steps to go through to get to the point where a guardian is appointed, so that person lacks sufficient understanding or capacity to make or communicate responsible personal decisions, including provisions for health care, food, clothing, or shelter because of mental disability, disease, habitual drunkenness, addiction to drugs, and this is important, that no less restrictive form of intervention is available that's consistent with a person's welfare and safety, and that is provided for in the statute. So just because a person, as I was saying before, has some issues with capacity, they may have difficulty in some aspects of their lives, but that doesn't mean that they need the guardian. There are other ways, less restrictive forms of intervention that may be available, and guardianship is considered the most restrictive form of intervention because there are so many people involved. The legal system is then intricately involved in the lives of the petitioner and the disabled person. Next slide, please. Okay, so examples of less restrictive interventions might be family guidance, just adult protective services, case management, etc. You can see on your slide there.
So, sorry.
Petitions are filed. And that may be because we have an aging population, many people who maybe would have died after a trauma or a medical condition. They are able to remain alive, but they may have some severe, sometimes, deficiencies and lack the ability to manage and make decisions for themselves. So one thing that is rising as an option, and I've been hearing a little bit about it in Maryland, and it's also going on nationwide, is the thing at the bottom, supported decision making, where a person who does have some disabilities, maybe an intellectual disability, but is high functioning, and they recognize that they need some help making decisions, and so they themselves appoint a person, and a legal document is created, and there's an agreement that someone who needs some help has a friend, a family member, they can appoint several people for different reasons, or they can have their first supporter, their second supporter, their third supporter, however they want to do it. So it gives everybody flexibility, and that supporter is supposed to help the disabled person gather information, make and communicate those decisions, give them the information that they need, and let them know what the benefits and the negatives are of such a decision, but leaving it to the disabled person to make the decision and to be there for them afterwards. Okay, next, please. Okay, the guardian of the property. So the guardian of the property has the legal authority and the legal duty to make and communicate decisions concerning the disabled person's assets, income, property, other financial matters, such as public benefits, income, pension, and so that's the guardian of the property. Next slide, please. So who may the court appoint a guardian of the property? So by preponderance of the evidence, again, the court finds that the person lacks sufficient understanding or capacity to make or communicate responsible decisions, this time concerning their property. Again, due to any mental disease, disability, disappearance, detention. And the slide doesn't say it, but it should include things like habitual drunkenness, drug addiction, and that they are entitled to property or benefits which require proper management. So at the note on the bottom, you'll see that the guardianship of the property does not require a mental disability. For example, you could be faced with a situation where the person is incarcerated and someone needs to manage their property while they are incarcerated. That's just an example of that. Next slide, please. Okay, so who may file a petition for guardianship? Not anyone can file a petition for guardianship. They have to have a connection in some way to the alleged disabled person that the court recognizes. So an interested person, though, is that person, him or herself, the alleged disabled person. Their heirs. The guardian is an interested person once that person is appointed the guardian. A person who has care and custody of the alleged disabled person. So for instance, if the alleged disabled person is in a nursing home.
Janet, excuse me for 1 second. I'm having trouble muting myself, and I apologize about that barking in the background. I'm going to step away for a second, but continue. I'll be right back.
Okay.
Sorry.
So if the alleged disabled person is in a nursing home or an assisted living facility or a group home, maybe with the Chimes or the Arc, those facilities are also interested persons. They must be notified of the guardianship. So, and also an agency paying benefits to the alleged disabled person. So if the disabled person is receiving Social Security, disability, etc., the Social Security agency is included and notified. And Caitlin will talk about that a little bit. And so again, MDLS is asking you to represent an interested person who is petitioning for guardianship. Likely that will be a family member or a close friend. Margaret, are you back?
Yeah, sorry about that.
Okay. All right, good. Next slide, please. Okay, so an interested person. So an interested person is the ADP, the alleged disabled person, the guardian, their heirs, or the governmental agency to serve as guardian of the person. That's for guardianships of the person. For guardianships of the property, you have all of those above, as well as a current income beneficiary of a fiduciary estate, the co-fiduciary of the estate, and the creator of a fiduciary estate. Next slide, please. Okay. And so I will soon be turning it over to Caitlin to take the rest of the presentation, but this, you see the steps that you will take for representing a petitioner in a guardianship case. So you will accept an assignment from MVLS. The MVLS paralegal will discuss the issues with you and give you the paperwork that you need and give you instructions on how to proceed. And you will meet with your client to discuss their issues, including how they need to obtain physician certificates, what we loosely call physician certificates, but Caitlin will get into the different kinds of certificates that can be obtained to get a guardianship awarded. So right now we are meeting with our clients virtually, either by telephone or FaceTime, Skype, those kinds of things. Hopefully we'll get to the point where we can meet with our clients in person again. And you arrange where you would like to meet your client. Maybe you want to meet your client in a public place. And I know that MVLS has office space sometimes where our volunteer attorneys will meet with clients, but that will be up to you and your comfort level. And then you will file the petition with the court clerk and everything that needs to be included in that petition. And then the court will issue an order appointing an attorney to represent the alleged disabled person. They will issue a show cause order, giving instructions, and the court will likely schedule the hearing date at that same time. Now, I can really only talk about Baltimore City and Baltimore County, which is where we represent the alleged disabled persons. And they both jurisdictions now ask us ahead of, they'll ask us, can you do a hearing on such and such a day? And then, so then the attorneys agree upfront, yes, okay, we will be there. Or they suggest a date. If it doesn't work for us, we'll say, no, we can't do that. How about this date? And that way you can arrange and work it into your schedule. It used to be that Baltimore City would just give us a date and we would just hope that we were available. Otherwise, we would have to seek a postponement. So then you would contact the alleged disabled person's attorney, and you would have to serve all persons and the alleged disabled person's attorney in the manner ordered by the court, and then file proofs of service by the date the court requires. In guardianship cases, service on the alleged disabled person's attorney does not equal service on the alleged disabled person. They have to be served separately. Even if that person can't read, or you're assuming that person can't read it, can't understand it, they still have to be served. Like, we'll go into a hospital and we'll see the manila envelope sitting next to our client, the alleged disabled person. Sometimes they have read it, sometimes they haven't, but they get it. They need to be served their own separate copy. And then you will attend the court hearing with your client, the petitioner, and your client will have to go to court. The alleged disabled person is not required to attend the court hearing. They have the right to attend the court hearing, but they don't have to. Some are incapable of it because they are too ill or they can't participate, but they also can't be kept away. If for some reason that person can't come to court, like sometimes we have cases where the alleged disabled person is hospitalized and the hospital refuses to transport our client to court. And sometimes that's because they fear that our client is a flight risk and they don't want to take the chance of that person running away, going to court. Then the hearing is taken to them. Everybody, the judge, the court clerk who records the proceedings, the attorneys, the petitioner, all go to the client. And that likely will not happen in your cases because your cases are probably just more family oriented. You won't have an institutional petitioner, but just keep that in mind that the alleged disabled person has the right, but is not required to attend the court hearing. Sometimes family members will decide, and I, as the attorney for my client, the alleged disabled person, if they get upset because their normal routine is disturbed, like they normally go to school, they normally go to a day program, and if they don't go there but go to court on a particular day, it might just disrupt them too much. So I agree that just let them go to school or their daycare, and we'll do the hearing without them, because I am their representative. So next slide, and I think we will move on to Caitlin.
Great,
Caitlin.
Thanks, Janet.
Thank you.
So the second half of the training is really the nitty-gritty practical steps on what does this all look like for you, the attorney for the petitioner. So the format of the guardian petition is in the rules. Like Janet said, there is a form petition that you can just use to, fill in the blank, but typically attorneys do write their own out. So as the rule says, the petition for the guardianship of an alleged disabled person shall be substantially in the following form. Next slide. Okay, so these are the requirements that must be included in the guardianship petition. the basic facts: who is the alleged disabled person, who is the petitioner, what is their relationship that makes them eligible to file the petition, what are they asking for? Are they petitioning for guardianship of person and property, or just one? And the reasons for filing the petition. So we often see in our cases, we'll see that the alleged disabled person, was hospitalized. Once they, were in the hospital, they were unable to communicate or give consent to treatment. And so that's why the hospital is filing a petition. Or we often see the nursing homes are trying to file for medical assistance insurance, and they're not able to get some of the financial information, so they need a guardianship of property. So whatever the reason for why the petitioner's filing should be included, why the petitioner is the appropriate person to serve as guardian, maybe want to describe, what their history is or what kind of care the petitioner is already providing. You want to make sure that you mention that they haven't been convicted of the crime that bars serving as a guardian that Janet had spoken about. You also want to list all of the interested parties that you are aware of. Additionally, if any less restrictive alternatives have been attempted, and what were they? And then you'll include the 2 physician certificates, which would attest to the need for guardianship. As the petitioner's attorney, you'd obviously want to review those forms and make sure that all the correct boxes were filled out that would support an appointment of guardianship. The notice to the interested parties, the advice of rights, and a pre-hearing statement, which we will go through. And you can see at the bottom of all the slides, all the citations and the court forms to look at your own leisure. Next slide. Okay, so for new guardians, the court would like them to watch a pre-appointment training video that's on the court's website. And then there is a court form, of course, that they would sign saying that they've watched it. It's a very short, like 10-minute video. The judges definitely would like this to be done beforehand, but I've seen in court where if the proposed guardian didn't do it, they can walk down to the clerk's office and watch it and sign it. But if you are an attorney that's representing a petitioner, certainly have them do this beforehand. Bring copies of the certificate of completion with you to give to the judge. After the guardian has been appointed, they have to attend a training, a much longer training, that's either in person or online. Typically, the judge will ask the guardian right then and there what day works for them, and they might propose a few dates. The guardian of person has to complete it with 120 days of the appointment, and the guardian of property has 60 days. And right now, all of the in-person trainings are obviously canceled because the courts are canceled. So you will see in the order how each jurisdiction wants them to complete the training. Okay, so then you'll have a whole petition packet that the petitioner must serve. This whole packet is going to include the petition, the 2 physician certificates, a blank pre-hearing statement, which we'll talk about, the order appointing the attorney, which is the court-appointed attorney for the alleged disabled person, the show cause order, the advice of rights form, the notice to interested parties or persons, and a proposed order. Okay, so we're going to talk about the medical certificates. So the rule is 10-202. There can be 2 physicians licensed to practice medicine in the United States who have examined the alleged disabled person, or it can be 1 licensed physician who has examined the alleged disabled person and 1 licensed psychologist or a licensed certified social worker. Again, they had to have seen and evaluated the alleged disabled person. One of the two examinations or evaluations must have occurred within 21 days of the filing of the guardianship petition. This is something that we as attorneys for the alleged disabled are definitely always looking at. So you want to make sure that your certificates are timely and that they're up to date before filing your petition, and that you file the original certificates with your petition. Okay, so after the petition is filed, the court will issue a show cause order. So the show cause order instructs the person to whom it is directed towards, it's either going to be the alleged disabled person or an interested party, to basically respond to the court in writing by a date specified in the order why the court should not grant the petition for guardianship. Default date is 20 days after service. It also specifies in the show cause who's to be served and the method of service required. And if the hearing's already scheduled, it'll state the date, time, and place of hearing. Every show cause order that I've seen in the last few months from Baltimore City have included the hearing date and time on the show cause. Okay. Okay, so the court will order an appointing attorney after the guardianship petition is filed. That's the alleged disabled person, and that is where MBLS holds a portion of the grant, so that's what we do. The alleged disabled person has a right to an attorney, and so the court will appoint someone, like Janet said, an attorney to represent them if they don't already have one. Okay, so the notice to interested parties, which is one of the forms that I talked about that must be included in the petition, would advise the interested parties of the petition and what they must do if they wish to object or participate in the proceedings. And then you can see the two different forms and rules for the petition for guardian of the person and property. Okay, then there's the advice of rights form. And this would also be included in your petition packet. And this would notify the alleged disabled person of his or her rights. And that would be to an attorney, which would include the name of the appointed attorney that the court has appointed, if they have appointed one. The right to a trial, including a jury trial. The right that the alleged disabled person has the right to be present at the hearing. They have the right to present evidence and cross-examine witnesses. Request restrictions or limitations to the guardian's powers, and request that the trial be closed to the public. Okay, so who must be served? The alleged disabled person. Like Janet said, even if you think they're not going to be able to comprehend the petition, you have to serve them. I often see the envelopes on the side of the bed of our clients. They have visitors who would open them. Sometimes the social workers can open them, so you have to serve them. You have to serve us, the alleged disabled person's attorney, or whoever the appointed attorney is, and all other interested persons. After service is accomplished, the petitioner must file the proofs of service, and if the service cannot be made, then the petitioner must file an affidavit of attempts to serve. We see this a lot. There's a lot of family members, but they don't, maybe your client doesn't know their address or their contact information, but they know they're out there. So, you know, it's okay if service can't be made, but you certainly want to file the affidavit that you've attempted to serve an interested party. Okay, so the law has a list of priorities of appointment for the guardianship of the person. So the priority list would go, you can kind of read it for yourself, but you know, number one, if the alleged disabled person has nominated someone that they want to be appointed, that is going to get top priority. An already healthcare agent that's already been appointed, that already exists by the adult or the alleged disabled person, spouse, parents, and then you can see as the list goes down. This isn't set in stone. A person can waive their right to, you know, a person of lower priority, maybe a spouse wants to allow an adult child to do it instead. The court may choose, you know, among persons of equal priority, or they might pass over priorities and appoint someone of lower priority. And a Maryland non-resident may also be appointed. So you don't have to live in Maryland to be appointed. So these are the guidelines, but there's obviously ways in which you can go around this list of priorities. Next slide. Okay, so if there is no one to be appointed for the guardian of person, then a public guardian would be appointed. This is called the guardian of last resort. I don't know if you would ever see this unless your client only wanted to file for guardian of property. But in these cases, an agency would be appointed by the court to serve as the guardian of person for an alleged disabled person who has no known or appropriate family members who are able or willing to serve. The local office on aging for the alleged disabled person would be for anyone 65 and older. The local DSS office is assigned for anyone between the ages of 18 and 64. So these are the contact information for Baltimore City for the Department of Social Service and the Office of Aging. These are the interested people who you would have to serve that petition packet that was discussed previously. And this is the corresponding information for Baltimore County. Again, DSS and Office of Aging. I will mention that sometimes we serve both Baltimore City and Baltimore County. You know, sometimes our clients will live in Baltimore City, but they end up in a hospital in the county, and maybe the hospital is not sure where they're going to be discharged. So, you know, typically, sometimes you would have to serve both Baltimore City or Baltimore County to make sure that you've covered your bases, depending on where the alleged disabled person ends up residing. Okay, then other interested parties that you may need to serve is Social Security Administration. If your client is receiving Social Security benefits, and those are the two contact information for Baltimore City and Baltimore County. Okay, so as the attorney for the petitioner, if you represent through placement by MBLS, you would qualify for a waiver of filing fees and costs, and MBLS will give you a form covering this information. Okay, so the next step would the guardianship hearing would be scheduled. It's on a fast track docket. Depending on what the circumstances are, you can have the case heard more quickly. We are seeing a lot of petitions filed right now on an emergency basis, and recently it was set in within about 6 days. You have to, in your filing, have to explain the grounds for an emergency. Just recently we had one granted in Baltimore County, and basically all it said was that COVID-19 is, you know, rampant in the nursing home, and they need the ability to make medical decisions on this client, and that was enough for the judge in that particular case. But I encourage you to review the statute, which is cited at the bottom, to make sure that you cover your grounds and getting your petition granted based on what the circumstances are in your case. Okay, so your client, the petitioner, has to attend the hearing. Like Janet said, the alleged disabled person has the right to attend, but they don't have to. We, as their attorneys, can waive their right to be present. Like Janet said, they might not be able to transport there, or because of a physical or mental disorder, they might not be able to participate. As we said, the alleged disabled person has a right to counsel, and they also have a right to request a jury trial. You'll often hear the alleged disabled person's counsel say, we waive our client's right to be present. We also waive their right to a jury trial. Okay. So then the court will generate an order, sometimes right then and there, and sometimes we just wait in the courtroom to get the order. The court has the power to grant a guardianship of the person for limited purposes or for a limited time. They can do temporary guardianship, or they can limit the powers of the guardian depending on the particular case. They also may limit the extent of medical decisions that the guardian may make without obtaining prior court approval. So once you get the court order, you just want to make sure you review it to see if the judge put any kind of restrictions or limitations on the powers of the guardian. Okay, so the court order appointing the guardian, this is just kind of what the order is going to include. It'll say whether it's for person or property or for both. It'll identify the disabled person, identify the guardian, identify basically the grounds for the appointment, whether or not a bond is required. Then it'll outline the specific powers and duties given to the guardian and any limitations on those powers or duties. It'll also include the date in which the guardian needs to attend their training, which is likely going to be online training right now. It'll also lay out the requirements for the guardian of person to obtain court approval before changing the disabled person's classification of abode, which means, moving the client or moving the alleged disabled person. Whether the guardian of the person is given the right to make medical decisions that involved a substantial risk to the life of the disabled person, and the dates in which the reports are due, both for property and for a person. Okay, so if you go to the court's website, they have a pretty robust guardianship page. There's a lot of self-help videos. They're very helpful, very user-friendly. Like we said previously, the orientation video, which the guardian needs to watch prior to the hearing. And then they also just have guardians of person video, guardians of property, guardians of both, and then an attorney guardian ethics program video. And you can find it by going to that website. Okay, so like Janet said, there is some case law that might be helpful to kind of review before taking one of these cases. The first one listed, Kitcherer, kind of just says that reminding everyone that the court is really the guardian, as Janet said previously. An individual who's given that title is merely just an agent or an arm of that tribunal that's carrying out that responsibility. So it's kind of just a reminder that the guardian is actually the court, and that the individual who is appointed guardian is an agent of the court. Mac versus Mac is about an application that a guardian had filed to withhold nutrition and hydration administered through a G-tube. So basically a wife wanted to remove the G-tube of her husband, who was previously competent. He got into a car accident and then was in a persistent vegetative state. The court held there that the evidence was inconclusive concerning what the patient would have wanted concerning the withholding of nutrition and hydration under the circumstances. And so the court concluded there that the court could not authorize the withholding of life support during that time. So it's kind of an interesting case if you want to review that. And then the last case, in re Sani E. Lee, kind of talks about the responsibilities of attorneys in these cases. This one's in particular to court-appointed attorneys for the alleged disabled person, but it kind of reminds us that it's our responsibility to explain the proceedings to our clients, to advise them, to keep their confidences, and to advocate for their position and protect their interests. If our client can communicate to us what their wishes are regarding guardianship, it's our job to really advocate for them for whatever they want in court. So those are just 3 case law they're kind of older, but they're still good law if you want to review them. Okay, next slide. Okay, so that is the end of our presentation. And I think Margaret is going to discuss kind of how to take a case from us.
Okay, Margaret.
Yep.
Yes, Margaret, can I add a few things first?
Yes, please do. And then while Janet adds a few things and then I'll go through a few slides, please take a minute to think about what questions you might have for our panelists and type them in. Please go ahead, Janet.
Okay, so we refer to the public agencies, and Caitlin had their names and addresses there, like the Department of Social Services and the Departments of Aging. They are always an interested person in a guardianship petition, even if it's a guardianship petition that is filed in interfamily, like a parent for a child. The public agency is still an interested person, even though they likely will not be appointed, but there's always a possibility they could be appointed. But they are entitled to notice. And sometimes they do their own investigation. Like sometimes they will, I know, like see if the petitioner has had any contact with Adult Protective Services. It might be a negative, maybe there's been complaints placed against that person in the past, or they've had contact or interaction with the alleged disabled person. They just get notice of it. So you have to include them in your petition. And there are now in each jurisdiction in Maryland, as far as I know it started with the largest jurisdictions in Maryland, meaning like the jurisdictions that have the heaviest caseload of guardianship cases. The guardianship cases are becoming so frequent that now the jurisdictions have hired what they call like a guardianship attorney or guardianship liaison. I deal with one in Baltimore County and one in Baltimore City, and they are attorneys that work in the courthouse. Their job is to manage the filing and the process of the guardianship petitions, and they are there to help you. They can answer some questions and to keep the case moving along. They may even contact you. So you're not out there alone when you file a petition. There is an attorney hired by the court that manages the cases flowing. And also, Caitlin mentioned a substantial risk to life, and the court order will say that whether or not the newly appointed guardian has the right to or not to make decisions that create a substantial risk to the life of the person. Now, substantial risk to life is not defined anywhere. It's kind of a case-by-case basis. Family members, like a petitioner that you would represent, are typically given the right to make those decisions. So, for instance, what we think of as being those kinds of decisions are end-of-life decisions. Like, will somebody get a feeding tube or not? Will they be put on a ventilator or not? Those kinds of things. Serious surgery where they're, maybe heart surgery where they're going to be placed under general anesthesia and they could die during the surgery. Those are considered a substantial risk to life, I would imagine. And like I said, the court usually gives those powers to a family or friend who's appointed guardian of the person because they know that person. The judge doesn't know that person, and the judge doesn't really want to have to decide that kind of thing if they can avoid it. But if a public guardian is appointed guardian of the person, then yes, they do have to go to court. And we have to go to court for our client if it involves our client. And there will be a hearing with physician testimony, etc., to make the case to the judge to allow the guardian of the person, whether it's the DSS or the Department of Aging, the court will allow that guardian to make that decision. The court doesn't order which decision the guardian is going to make. The court just gives the authority and the permission to the guardian, the public guardian, to make a decision. And I guess that's all for right now. Thank you.
All right. Thanks, Janet. And again, thank you so much to both Janet and Caitlin for taking the time to do this presentation. I know I found it very informative, and I'm sure the audience members did as well, so thanks so much. I am just going to cover a little bit about how to volunteer with MVLS and some of our other trainings that we have coming up. So one of the things that I just wanted to highlight is if you're just interested in getting updates about what MVLS is doing and what we have going on, you can follow us on social media. We are on Facebook, LinkedIn, Twitter, YouTube, and we post pretty frequently about upcoming events and trainings and things like that. So please feel free to do that if you are interested. When you volunteer with MVLS, there is an easy way to just kind of browse cases and see what's available, and that is our pro bono portal. So when you go on our website, at the top, you'll see something that looks just like what's on your screen right now, and one of the options you can click is pro bono portal. And when you click that, something will come up that looks like these little cards that you see on your screen in front of you, and you can sort it by case type and you can sort by county to try to find the type of cases that you're interested in taking. So this is probably the easiest way to just kind of browse what we have available and see what case you might be interested in. And then when you click on learn more, that'll be sending a message to the paralegal, the MVLS paralegal who's assigned to that case, and that paralegal will connect with you to answer any questions, get you more information about the case, and facilitate you taking the case. If you prefer to just kind of reach out by phone or email to our paralegal team to see what cases we have that we need to be placed, you can also feel free to do that. We are here to support you in doing this pro bono and help you in any way you can. I think it was Janet who mentioned, if you have questions as you're going through your case, we want to provide that support and mentorship for you as well. So please do reach out to us if there's anything that you need. I also wanted to mention that we do offer quite a few training opportunities. Right now, all of our trainings are webinars, so you can do them from the comfort of your home. We have one on April 14th that is a tax webinar about self-employment tax pitfalls, and we have one on April 16th that is about ground rent, and you can sign up for either of those webinars on our website if you're interested. And in addition to those, we have trainings available in basically all the different areas in which we take cases that you see on your screen now. And so if you feel many of these trainings are available to you and free to you. A couple of them do include a requirement to take a pro bono case, but you'll see that all listed on the website. And if you are interested in taking one that requires a pro bono case, just reach out to us and we can give you the access to that training and facilitate you getting the case. Finally, if you are not a volunteer and you're watching this webinar hoping to become a volunteer, we would encourage you to sign up today. We have a form on our website. The link is on this PowerPoint to apply to be a volunteer, which is simply giving us some basic information about yourself, contact information, when you were barred, that sort of thing. And we will follow up with you to find a case that is right for you. So we really appreciate you being an MVLS volunteer and taking this training and taking an interest in guardianship cases. Again, feel free to we'll have a couple minutes for questions now. One question that I have to kind of kick it off is, as attorneys who represent the alleged disabled person, Caitlin or Janet, are there kind of mistakes you've seen the attorneys on the other side make, I guess, for our volunteers, they'll be representing the petitioner, or mistakes that you've seen pro se parties make that you would say, okay, here's something that's kind of a common mistake. Make sure not to do this.
Sometimes pro se petitioners don't bring their documents with them to court. I would hope that an attorney wouldn't make that mistake.
Yeah, hopefully not.
But it happens. Make sure that your client has watched the video beforehand and does come in with them a signed copy of the form that they attesting that they have watched the orientation video, and they sign it. Nobody has to sign it for them or co-sign it. Like it's just on the honor system. They just need to sign it. Make sure they bring the original to court with them. Yes, make a copy of several copies of them so that you have a copy and that your client can keep a copy. But the judge is going to want the original of that form. Sometimes I've had petitioning attorneys who don't, I guess, really understand that there are some little intricacies or unusual things about guardianship cases. But I do find that the judges in guardianship cases are kind. They see these cases as like less adversarial, and usually they are, especially in a case I think that our volunteers will take. They will be representing a petitioner in an uncontested case.
Right.
The judges are very appreciative of people who are willing to step up and wanting to help a loved one, and they are thankful, and they are very nice to the lay people in the courtroom too, in those circumstances. So it's not really something to be afraid of.
Good. Good.
Caitlin, do you have any mistakes that you've noticed?
All right, Ted. No, I don't think I have anything to add.
Okay. You talked about the court looking at whether the person, the alleged disabled person, lacks capacity. What about a situation where the person does have some level of capacity, maybe a situation where they have capacity that comes and goes, like it would be more, they'd be more mentally present at some times than others, and so that person does have some level of capacity, but they do consent to a guardianship. How would the court look at that?
If the alleged disabled person agrees to the guardianship, then my experience is that the guardianship will be awarded.
Mm-hmm.
Caitlin had an interesting case recently where her client is pretty high functioning, but does have some issues, and she recognizes that she can't take care of herself, but she has sought help from the community because she was living in the community and then ended up in the hospital. And she has a public guardian, but the public guardian has allowed her to go back home and obtain community services to help her remain as independent as possible. Caitlin, you might want to go into that a little bit without giving specifics.
Sure. Yeah. So it's a very unique case, is what the department is telling me, that they don't normally have this. But she is pretty high functioning. But we're, the court appointed a guardian, obviously, over our objection. I put on a case and I brought witnesses from the community, from the community doctor that she saw, and what kind of services were already in place in the community to try to show that a guardian wasn't necessary. But I think it turned out for the best right now. And, you always have the option to try to terminate a guardianship down the line. So my client's hope is that when she gets home and has a lot of services in place, maybe we can get to a point where we can ask for her guardianship to be terminated.
Great. That is helpful, kind of on hands-on advice from your cases. how common is it to have different guardians of the person and property? Is it in most cases that it would be the same person?
In the cases for which we are appointed, it's frequent because it is an agency, or rather an institutional petitioner, a hospital, a nursing home that petitions. And they petition because their patient doesn't have any known friends or relatives who are willing to step in and serve as guardian to make medical and financial decisions. In those cases, the public option is chosen, meaning they end up with a public guardian of the person, and then an attorney is appointed guardian of the property. And in those cases, it's often the guardian of, it's often just a guardianship to get medical assistance in place. And then the attorney will then petition the court to terminate the petition after all of those issues are resolved. Or it might be a permanent guardianship, that also happens. Sometimes our clients have more assets to manage than normal for us. And often, well, sometimes even in our cases, maybe there are several family members who come forward, and one family member wants to be guardian of the person and a different family member wants to be guardian of the property. That happens too. I would imagine that our volunteers are usually going to have clients where the client wants to be the sole guardian of both. But there, so there's really no one answer. I mean,
yeah, no, I know. I think that is usually true. We did recently have a case where the person was, I believe it was only guardianship of the property that the petitioner was seeking. But yeah, that usually it is the case that they're trying to get both. Okay. What happens if the person who has been appointed guardian dies? What then is the process to potentially appoint someone else guardian?
The court will appoint a substitute guardian. We do have cases such as those that come to us. For instance, say mom was appointed guardian of the person and maybe guardian of the property of her daughter, and then mom dies. Well, the court doesn't know that mom died because nobody notified them, and who would probably, most people probably wouldn't think or come across maybe the document or even know that mom was guardian for her disabled daughter. So the time comes when mom should have filed her annual report as guardian, and she doesn't, and the court can't find her. And then the court issues a show cause order, and nobody shows up for the hearing. And then it's finally discovered that mom has died. And so then the court will ask us to get involved. And then we do our own investigation, confirm that the mom certainly has passed away, and that the alleged or the disabled person still has their disability and guardianship is still appropriate for them. The court just needs to appoint a substitute. And so there might be another family member who will step in to do that, or sometimes at that point, the guardianship then becomes like a public guardianship where there are no other family members willing or able to take over with those responsibilities, and so then DSS or aging would become their guardian. So and sometimes we are appointed as attorneys for the disabled person because the guardian, for whatever reason, doesn't want to do it anymore or feels like they're not capable of doing it anymore. And we've gotten a number of those cases where it is a parent who has just gotten more elderly and frail, or has cancer, or they themselves are maybe approaching dementia and they realize it, or a family member realizes it. And so they ask the court to remove them and substitute them. Sometimes they will ask the court to remove them and appoint a substitute in their annual report. And there is a spot in the form for the annual report where the guardian is given space or an option to say, the guardianship should continue, but the court should find a different guardian, and this is why. And then the court will get that substitution process moving forward.
Okay. I believe it was Caitlin that mentioned that the alleged disabled person can request restrictions to the guardianship, the guardian's powers. What are some examples of restrictions that you've seen people request?
Okay. Yes, the law does say that, but in reality, it's not done very frequently in Maryland. And
okay.
it's just like a broad power that's given. Let's see, I did have a case where the order did specifically order the guardian of the property that they did not have the right to sell the disabled person's house, because the disabled person was hoping to be able to leave the nursing home and go home someday. So the guardian of the property had to file a separate motion with the court to be given the right to sell the house if and when the disabled person was determined not to be able to go home, would end up being a permanent long-term resident of the nursing home. We recently had one where the court ordered that the person still had, there was a way the order was worded, it was changed, and it was worded oddly where the person could still choose where they wanted to live. That created problems, so that's been changed. The courts in Maryland tend not to set out exceptions to the power of the guardian. They can, and it would be up to the, I guess, the alleged disabled person's attorney to really argue for why that should be done, because my experience is that judges are just in the mindset of doing the basic order and granting all powers that a guardian would have, as though the guardian were the person themselves or the person's parent, a parent for a minor child. It gives them all those rights.
All right, thank you. I don't see any additional questions. So thank you so much to both Janet and Caitlin for doing this presentation. Thank you to our audience for being with us and for volunteering. And I believe, unless either of you have any final thoughts, that concludes our webinar today. Thank you.
No, that's it. Thank you.
All right, thanks so much.